Welcome to Synergy Consulting Knowledge Series. In this segment, we discuss practical financial and legal challenges that businesses face every day. Today, we are taking up an important question. The question is it necessary to hold an annual general meeting during the corporate insolvency resolution process, even when there is no ordinary business to transact? Please note, the views expressed in this video are meant for general information and educational purposes only. Anyway, let's find out. The background of this entire presentation is that whether a company undergoing corporate insolvency resolution process under IBC is required to hold an AGM in terms of Companies Act 2013, particularly when the company's operations are non-functional or suspended since long. The annual accounts are not ready due to non-cooperation of the outgoing management. No dividend is to be declared. No appointment of the director or auditor is proposed. And no special business is intended to be transacted. What is the legal framework in this regard? You see, the Companies Act 2013, Section 96(1) of the Companies Act 2013 mandates that every company other than a one-person company shall in each year hold, in addition to any other meeting, a general meeting as its annual general meeting. However, the Act is silent regarding companies under CIRP and does not explicitly exempt them from holding AGM. There are so many judicial precedents in this regard. You see, in the matter of Rico India Limited, the NCLT observed that once a company enters CRP and the management vests with the RP, normal corporate compliances such as holding of AGM or corporate or approval of accounts may not be practically possible till the accounts are reconstructed and verified. NCLT New Delhi bench in the case of Mrs. Bhushan Steel Limited also took note that the RP cannot finalize accounts or conduct AGM until the financials are reconstructed and CRP proceedings are stabilized. Thus, tribunals have recognized the practical and legal impediments in holding AGMs during CRP. Let us do the analysis. What is the purpose of holding AGM? You see, the AGM primarily serves a couple of purposes. First is approve annual accounts under Section 137, declare dividend Section 123, appoint directors and auditors Section 152 and Section 139. Where none of these actions are possible or proposed, the very purpose of holding the AGM is defeated. Let us see operational reality under CRP. The company's management stands suspended and the RP takes over control. The preparation and audit of accounts may be pending or disputed due to unavailability of records or verification of claims. Conducting an AGM would be purely procedural without any substantive business to transact. Hence, what practical approach is normally adopted by RPs? In practice, RPs often file applications to NCLT seeking directions or extensions under Section 96(1) for non-holding of AGM during CIRP, citing lack of finalized accounts and ongoing insolvency proceedings. Hence, the conclusion is holding of AGM during CIRP is not mandatory when the circumstances make it impossible or impractical, particularly where the company's accounts are not finalized or audited, no ordinary or special business is proposed, the management is under suspension and the RP is in control, and CIRP proceedings are ongoing before NCLT. The RP may seek appropriate directions or condonation from the NCLT to protect against technical non-compliance under Section 96, read with Section 403 of the Companies Act 2013. That is all for today's episode of the Synergy Consulting Knowledge Series. We hope this discussion helped clarify the legal and procedural aspects of holding an aging deed in CIRP. This is CA Praveen Agarwal signing off. Thank you for watching and stay tuned for more insights in our upcoming videos. Thank you.